All right, I understand we're here today on the defendant CSI's motion to disqualify, is that correct?
Yes, sir.
Okay. And I guess you've seen, or you want to respond to their issue on standing that was raised in their response?
Of course. I intend to address everything before the court. As I understood the court's instructions yesterday afternoon, there will be a 5-minute or so opening by each side.
Sure.
With the recording devices present. At the end of those opening statements by each side, that aspect of the meeting will leave, and then we will begin the actual presentation of the motion itself. Yes. And I'm prepared to begin my opening statement.
Okay.
The court, please.
You may.
Thank you, Your Honor. Again, George Spencer, one of the attorneys for defendant, Church of Scientology International. Yesterday, in his opening remarks in this courtroom, plaintiff's lead counsel, Ray Jeffrey, made it very clear that the chief goal of this lawsuit is to pursue and attack David Miscavige, who is the leader of the Church of Scientology. A quote from Mr. Jeffrey yesterday. Our basic premise is there is really one man behind this harassment of Mrs. Rathbun. That was yesterday. 2 weeks ago, on August 28th, Mr. Miscavige's attorney, Lamont Jefferson, filed a document titled Special Appearance on behalf of Mr. Miscavige, his client. And in that special appearance pleading filed with the district clerk in this court, Mr. Jefferson very properly urged that while the plaintiff, Mrs. Rathbun, is of course entitled to her day in court to see if she can in fact prove her allegations against Mr. Miscavige, she must do so in California. Mr. Jefferson, Mr. Miscavige's attorney, set that special appearance hearing for the 12th, for yesterday. In response, and because the legal arguments advanced by Mr. Jefferson on behalf of Mr. Miscavige were so clear and so well settled under Texas federal and constitutional law, Mrs. Rathbun's attorneys decided that they would try a desperate move to keep this case against Mr. Miscavige here in Texas rather than refiling it in California and pursuing it there, which is the appropriate location. Mrs. Rathbun's counsel decided to get her husband, Mark Rathbun, to give an affidavit, a sworn statement made under oath, the same oath the witnesses taken in this courtroom, that they hoped would be enough to at least tie up Mr. Miscavige in Texas courts for some extended period of time. They filed that affidavit of Mark Rathbun along with an amended petition on September 4th. As I said, it was a desperate move, and I chose that word deliberately. There is, of course, absolutely nothing wrong with plaintiff's counsel attempting to keep their client's case against Mr. Miscavige here in Texas, provided they do so within the bounds of the law and provided they do so ethically and appropriately. But in their zeal to do whatever it takes to go after, as Mr. Jeffries said yesterday, this one man, David Miscavige, they crossed a huge ethical line. They didn't just put a toe over that line, they jumped over it and came down hard with both feet on the other side of it. In the affidavit that Mark Rathbun, the plaintiff's husband, swore to, and that plaintiff's counsel filed in this case on September 4th, Mr. Rathbun sets out under oath how he was intimately involved in and knowledgeable about the legal affairs of both my client, Church of Scientology International, and our co-defendant, RTC, Religious Technology Center. He said that for over 20 years, no legal litigation matter could occur involving either of the defendants, both my client and Mr. Jefferson, without his involvement or knowledge. And in an effort to keep this case in Texas, Mr. Rathbun described not simply the hiring of lawyers or attorneys in Texas, arguably a legitimate object of testimony and evidence in this context, but he went way beyond that and described the supposed substance of the communications between himself as a legal affairs person and the attorneys. Now, Mr. Rathbun's description of the substance, of the content of his communications with those Texas attorneys is false. But that is not the issue for today. That falsity can and will be dealt with fully at a later date. Instead, what is important, what is the focus of this morning's hearing, is that on its face and unmistakably, Mr. Rathbun's affidavit purports to reveal confidential, privileged communications he had while he worked on the legal affairs of the defendants and that he had with the attorneys for the defendants. It's impossible that plaintiff's counsel could miss this blatant breach of attorney-client privileged communication. It's impossible that plaintiff's counsel could not know, impossible that they were not fully aware of the importance to our system of justice that clients be able to speak freely and openly to their own attorneys with the assurance that those free and open communications will not be revealed and cannot go out of the room in which they were spoken. Now, plaintiff's counsel have done this. They filed Mr. Rathbun's affidavit as a public record. And as a result, the course of action that this court is to take is clear. Plaintiff's counsel must be disqualified under Texas law. They are working with the plaintiff's husband on this case. The plaintiff's husband, Mark Rathbun, was, by his own sworn admission, filed in this court less than 2 weeks ago, intimately involved in the legal affairs of the defendants for decades. He is conclusively presumed under the law to possess, quote, confidential information, close quote, a technical term which is expansive and goes far beyond simply privileged communications. It includes privileged communications, but it is expansive and includes everything that Mark Rathbun knows relating to the legal affairs of these defendants, both privileged and unprivileged, that he learned during the time he was working on the legal affairs. We would be in a totally different situation, perhaps not even here at all on this day, if plaintiff's counsel had properly and appropriately taken precautions to prevent Mr. Rathbun from revealing the confidential information he has. Indeed, the case law, the reported case law in Texas, is an analysis. The reported cases in Texas are analyses of whether the person with confidential information was properly and thoroughly and completely advised of the critical importance that he not reveal that confidential information to the attorneys, and whether sufficient structural safeguards were built in to the attorney's relationship with the person, such as Mr. Rathbun, to prevent inadvertent disclosures of confidential privileged information, the so-called Chinese wall, as many court opinions have likened it to. But those are not the facts here. That is not what is before this court. No, the fact here is that on its face, in the affidavit of Mr. Rathbun that was attached to the pleading that the plaintiff's counsel filed in this case, is a revelation of several pieces of confidential information, including the purported communications with lawyers in Dallas about bringing a suit in Texas, which is their attempt to show that Mr. Miscavige should be required to litigate here in Texas rather than California. That affidavit conclusively proves that Mr. Rathbun is sharing confidential, even the highest level of confidential information, privileged information, with plaintiff's counsel. And when that occurs, when it is established that a person such as Mark Rathbun has revealed confidential information to the other side's lawyers, then the law, as repeatedly expressed by the Texas Supreme Court, requires disqualification of those attorneys. My client, CSI, does not have to risk further improper disclosure. As the Supreme Court described it in the American Home Products case, which we gave a copy of that to the court yesterday evening.
I read it.
Yes. As the Supreme Court said, the risk that a person who has functioned as Mark Rathbun did, the risk that he may disclose confidential information to the other side, quote, is unacceptably high. Now, plaintiff's counsel, both in the initial response that they filed yesterday and in the supplemental response that they handed to me out in the hall here a couple minutes ago, have no valid response to the line of Texas cases that controls. Instead, what they engage in, quoting Wikipedia, a source that I think we heard yesterday, if you rely on Wikipedia, you believe Mr. Rathbun is dead. But they resort to polemical statements, polemical arguments, and to the extent that they have a legal response, one rooted in case law and in authorities, what it is to cite to a completely distinguishable and inapplicable line of cases that are in parallel, but are distinguishable and are not applied in this situation of a person who was actually working in the legal affairs of a party and then goes over to the other side. And I will address that in much greater detail about the distinction between those kinds of cases. But the ones they cite are not applicable to this situation. Let me say, to wrap up this part of my presentation, I take no joy in bringing this motion, but it needs to be done to safeguard the rights of my clients. And I know you take no joy, Judge Waldrop, in having to disqualify lawyers, but you do so to safeguard our system of justice. I was among the lawyers for the American Home Products case in the Supreme Court that I just mentioned, and I filed that motion because it also had to be done. Sadly, this is the second time that I have had to bring a motion such as this against these very lawyers. But at the end of the day, my personal feelings about this are really not important at all. And important, but not supremely so, is the fact that this is not the first time that these lawyers have crossed this ethical line in litigation against my client. What is of paramount importance is that under the undisputed facts, the facts established by the affidavit of Mr. Rathbun, which is in the court's own file, is that confidential information of my client, CSI, has been revealed to plaintiff's counsel and they've misused it. They must be disqualified further with respect to this. Thank you.
On behalf of the plaintiff and also on behalf of my co-counsel whose disqualification is being sought by the defendant as well, although they are both being subjected to this highly offensive, dilatory tactic, as am I, and they may need to interject at some point as well, which I think is their right. Your Honor, I would be amused at the manufactured tone of outrage by Mr. Spencer if it weren't for the fact that what he's filed is a motion saying that I and my co-counsel are guilty not only of unethical but immoral conduct. And it is a completely and utterly baseless motion, which